Prince Andrew risks incurring the wrath of the judge in the Virginia Roberts sex abuse trial by having his lawyers shun a pre-trial hearing today. Plans by Prince Andrew's lawyers to boycott today's court hearing in his sexual assault civil case risk angering a New York judge, reports suggest. Legal papers finally delivered to the Duke of York's Windsor home were not properly served, his team claimed over the weekend, meaning lawyers are considering not taking part in the pre-trial hearing. Andrew is being sued by Jeffrey Epstein victim, Virginia Roberts, who claims she was sexually assaulted by the Duke. He vehemently denies the allegation. But while the Prince's team are said to have signaled their intent not to participate in the telephone conference today, Judge Lewis Kaplan has ordered that both parties in the case are directed to confer regarding an agreed scheduling order, according to the Telegraph. Judge Kaplan is looking to lay out a timetable for management of the case, and if Andrew's lawyers refuse to dial in for the hearing, it may be seen as being in defiance of his order. It comes after legal papers were finally accepted by the security chief at Andrew's Windsor home over the weekend after weeks of avoiding officials, court documents dramatically revealed. The clock is now ticking on the Duke of York, who has 21 days to respond, or he will face a default judgment. But Andrew's lawyers claimed the papers were not properly served, and hope to get the case thrown out on a technicality. In a legal filing, his solicitor Gary Bloxham said the document Miss Roberts signed in 2009 may make her action invalid. It is the first indication of how the Prince and his lawyers intend to fight the case after weeks of silence. On Friday, a new affidavit was also lodged in New York from a London-based corporate investigator and process server, Cesar Augusto Sepulveda, who was employed to personally serve Andrew with court papers relating to the U.S. action. He records how he first went to Royal Lodge, Andrew's Windsor mansion, on August the 12th, and was met by Metropolitan Police officers guarding the gate who told him they could not raise anyone in charge. They said they had been instructed not to allow anyone attending there for the purpose of serving court process on the grounds of the property, and they added that no documentation would be forwarded on, leaving the server with a strong impression they had been primed. But Mr. Sepulveda returned on August the 27th, and was told he could now leave his papers and they would be forwarded. In other court documents, Roberts' lawyer David Boies detailed the extensive efforts they went to in order to serve Andrew. They said that on August the 12th, 4 days after filing the lawsuit, he sent copies of the summons and the complaint to 5 different lawyers from 3 law firms who they had reason to believe represented the Duke. On the same day, Boies' team emailed the same documents boy.office@royal.uk, the Duke of York's public email, and got a response acknowledging the email. On August the 18th, a copy of the complaint and summons was sent to Blair Burke, the Los Angeles lawyer who reportedly represents Andrew. The next day, Claire Montgomery of Matrix Chambers in London replied that she was not authorized to accept service on behalf of the Duke. On August the 26th, Boies said that his lawyers sent Andrew a copy of the summons and the complaint at Royal Lodge via a same-day courier service. They also sent a copy by regular post in the UK and via FedEx, which was sent on August the 16th and was delivered on August the 20th. According to Boies, these measures ensure they have properly served the summons according to the rules of the Hague Convention on the Service Abroad of Judicial Documents, to which the US and UK are parties. The serving has now been ratified under civil procedure rules as required by the Supreme Court of England and Wales. There was no comment from the Duke of York's legal team last night. They are now trying to access the sealed document Miss Roberts signed via the US courts, because they believe it may prevent the case from progressing. The initial hearing is at 9 p.m. UK time on Monday in a conference call before a Manhattan judge. Miss Roberts' representatives have indicated they will fight the move by the Prince's team, saying there is no evidence he was ever intended to be covered by the previous legal agreement. The 38-year-old, who is arguably Epstein's most high-profile victim, has repeatedly accused the Queen's son of having sex with her 3 times, when she was aged 17 in London, New York and the British Virgin Islands. Last month she launched a surprise legal move, lodging a civil claim against the Prince for rape, sexual assault and battery. Andrew, 61, has refused to comment on the case, but has previously strongly denied her claims. Miss Roberts alleges she was scouted and groomed as a schoolgirl by Epstein and his then-girlfriend, Ghislaine Maxwell, before being used by the billionaire financier as an underage sex slave. In 2009 she reached a confidential settlement in Florida with the financier that may contain clauses which prevent her from taking action against individuals she has accused of being co-conspirators of the tycoon. One of those was high-profile U.S. lawyer Alan Dershowitz, who previously represented Epstein. He was accused of sexual assault by Miss Roberts in 2019. But last month she reportedly dropped the claim because of the Epstein settlement, which released him from liability. Her withdrawal was described in a joint court filing last month as a compromise that should not be viewed as an admission by either party of the validity or invalidity of the claims about the settlement agreement. Mr. Dershowitz has lodged the request with the Manhattan court dealing with the action against Andrew to have the original agreement unsealed, as he believes it may help to get the case against the Prince thrown out. The Harvard law professor said yesterday, "We strongly suspect that Virginia and her lawyers may have committed fraud on the court by filing a lawsuit against Prince Andrew after dismissing the battery case against me. The same reasons for dismissing the case against me seem to apply to Prince Andrew. These documents should get the charges against Prince Andrew thrown out. It's an airtight defense for Prince Andrew and a potential fraud on the court." But Miss Roberts' lawyer, David Boies, has said there was no evidence Prince Andrew was intended to be covered by the release. Mr. Boies said he was unable to comment on the details of her settlement with Epstein, citing its confidentiality, but added, "What I can say is that there is no evidence that Prince Andrew was intended to be covered by the release." And, indeed, Prince Andrew has never himself asserted that he was intended to be covered by the release. In a letter obtained by ABC News in the US, Mr. Bloxham described the methods used by Miss Roberts' legal team as objectionable. In correspondence with a judge, he said, "They have made several public, indeed well-publicized, attempts at irregular service of these proceedings in this jurisdiction, in at least one case accompanied by a media representative." Mr. Bloxham maintained that under British law, a valid request for assistance from UK court officials must come from a judicial or diplomatic officer in the US. US District Judge Kaplan must now decide whether Andrew has been officially served. If he does, the Prince will be given a deadline to respond.